Breaking news out of the state of Maryland. The Maryland Shall Issue organization, along with a series of other plaintiffs, have managed to knock out a goofy law by Montgomery County, Maryland. Another anti-gun jurisdiction has been spanked badly by a Maryland state court judge, not on Second Amendment grounds, but on state preemption grounds, which in this case is just as good. We're going to talk all about it when we get back. Hey folks, I'm Mark Smith, host of the 4 Box of Nine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, what the Ukraine War teaches Americans about the right to bear arms. All right, folks, another big win for Maryland Shall Issue, Inc., a major gun rights organization in the state of Maryland, hot off their big victory in the United States Court of Appeals for the Fourth Circuit, where they knocked out the handgun qualification license imposed by the state of Maryland. A set of plaintiffs, including Maryland Shall Issue, has actually knocked out a Montgomery County set of laws in one particular county in Maryland, in Montgomery County, which tried to exceed the scope. It tried to expand upon restrictions on Second Amendment rights in that county, but a Maryland state court judge says no go. I should make one technical note that Maryland Shall Issue, the organization itself, was actually dismissed from this lawsuit in this case due to alleged lack of standing, but the other plaintiffs that sued along with them prevailed. Big news, big win for effectively the Second Amendment, even though this case, again, doesn't deal specifically with the Second Amendment, although it does deal with Second Amendment rights. So to begin with, the state of Maryland is not a good gun jurisdiction. We know that they're basically blue state, anti-gun jurisdiction. They do this mostly because they want to keep places like Prince George's County in Maryland, as well as Baltimore, very safe. And they do a great job both in PG County and in Baltimore of keeping the people safe there with all their great gun control laws. Nevertheless, let us carry on. Montgomery County decided that they did not think the state of Maryland's laws were egregious enough or anti-gun enough, so they tried to take it to the next level. Specifically, what Montgomery County did in their county was they tried to expand really the definition of where you cannot bring a gun. They tried to expand the scope of quote-unquote sensitive places or government-mandated gun-free zones. Specifically, they expanded the definition of what is considered a place of public assembly and within 100 yards of that. Specifically, what Montgomery County did is they sought to regulate where a person could carry or possess a firearm by expanding the concept of quote-unquote place of public assembly. A place of public assembly is defined under the relevant ordinance of Montgomery County as any place where the public may assemble, whether the place is publicly or privately owned. And this includes all property associated with that place, whether public or private, including parking lots and grounds. According to the plaintiffs, Maryland Shall Issue and the other plaintiffs, Montgomery County seeks by this device, by this argument, or this law, ordinance, to make it illegal in Montgomery County to make illegal in Montgomery County conduct that is expressly permitted by state law. Moreover, Montgomery County tried to also expand the regulations associated with personally manufactured arms. These are do-it-yourself guns, homemade guns, self-made guns, which, of course, we have a Second Amendment right to, but this case is not about that, including what the county has defined as a ghost gun. The plaintiffs argued here that the way the ghost gun was defined under Montgomery County ordinance law was much broader than it was defined under state law, and therefore Montgomery County was expanding and restricting the right to keep and bear arms in a way beyond what the state had done, and thus it had to be what's known as preempted. Now, just to let you know, this is a critical term. You're going to hear a lot about this in the future. Preemption. Now, what is called state preemption is the following. A state will often pass a law that says the following. It says, or maybe in the state constitution, that local governments or town governments or village governments within a particular state, to the extent they enact laws, that are inconsistent with, like, state law, or they are more restrictive than state law when it comes to the regulation of firearms, then the local town village laws that are inconsistent or more expansive in terms of more regulation than state law, those local laws are preempted by the state law. Now, this is for a variety of reasons, one of which is the state wants to have a uniform, consistent approach to regulating firearms and firearms-related conduct, number one. And as a practical matter, you also, from the point of view of the gun owner, you want to know what the law in the state is, and you don't want to have to know what every law in every little jurisdiction is that you drive through. You drive from a village to a town to a city to a village to a city, and you can't know what all those different gun laws is. Simply impossible, and it's unfair to the law-abiding gun owner, and also it's not appropriate for the state who wants uniform rules associated with guns. So what happens here is Montgomery County is trying to expand the definition of plaintiff assembly and trying to expand the definition of ghost guns, so they make it harder to do those things in Montgomery County than would be the case in other parts of the state of Maryland. But I'm happy to report that the Maryland court judge saw right through this and specifically declared that both the ghost gun regulation of Montgomery County as well as the restriction on the sensitive place issue associated with places of public assembly both were preempted by Maryland's preemption statute that doesn't allow for local gun control laws that are more restrictive than the state's. Specifically, the court wrote, in the court's view, quote, in the court's view, and as the counsel for the county, for Montgomery County, conceded oral argument, the county wanted, among other things, to largely eliminate the state granted right to wear and carry a firearm in Montgomery County, even when the individual held a state-issued concealed carry permit. Chapter 7 of the Montgomery County law that was being challenged, as intended by Montgomery County, effectively bans the concealed carry of a firearm in Montgomery County outside of one's home or business, effectively nullifying a state-granted right to those who have applied for and received a concealed carry permit by the Maryland State Police. In the court's view, this effectively swallows the preemption provisions of Maryland law, as well as other state laws expressly regulating handguns and the right to possess or to carry a handgun in this state of Maryland. If such a law is to be enacted, it is for the General Assembly of Maryland to do so, not for a municipality. Very powerful language by the state court judge. Now, I should go on to say that specifically, this court explains what the Maryland preemption statute's all about. He points out that the Attorney General of Maryland, who's now a state court judge, explained that the, quote, evident intent of a preemption provision like this law, this criminal provision associated with the state preemption law, is to ensure some uniformity in statewide regulation of firearms. As illustrated above, the challenge provisions of Montgomery County undermine, conflict with, and largely undercut the General Assembly's stated goal of statewide uniformity for handgun and firearms regulation. So the judge found there was a conflict between Montgomery County, what they were trying to do, and what they're allowed to do, and as a consequence, these ridiculous laws dealing with expanding the scope of the place of public assembly where you can't carry a gun, and expand the scope on quote-unquote ghost guns, which are nothing more than unserialized guns, were expanded by Montgomery County beyond the scope of the ATF regulations, as well as the state of Maryland's regulations, by the way, and the state court judge says no can do. All right, to wrap up, the state court judge in Maryland said that these Montgomery County provisions dealing quote-unquote ghost guns and the scope of places of public assembly were too restrictive because they exceeded what was allowed under Maryland state law, and thus they were preempted by the state's preemption law. And the court went on to conclude by saying the comprehensive and intertwined scheme of existing state regulation preempts Montgomery County's efforts through Chapter 57, the relevant law, to place additional legal hurdles on the wear and carrying of permit holders, state licensed firearms dealers, and privately made firearms. The relevant section of the Montgomery County law simply does not allow a county effectively to nullify nearly all of other state firearms rights and restrictions, at least not in the manner attempted to do so in this particular ordinance. The court concludes that the challenge provisions of this Montgomery County law conflict with and are preempted by state law. A political subdivision in Maryland simply cannot prohibit, save for very narrow exceptions, what is expressly permitted by state law. To hold otherwise would allow a municipality to substitute its will for the will of the Maryland General Assembly. The exception, to the extent it exists, the exception to preemption in this particular state preemption statute is simply not that wide. Powerful language by the judge. I will put a link to the decision down below. And again, hope you learned something here about state preemption laws. Again, just to be clear, a state preemption law says that an inconsistent local law that is more restrictive on the right to keep and bear arms than a state law is preempted. We in the Second Amendment community want preemption laws because otherwise it will be simply impossible for American gun owners to be able to travel across a state because it's almost impossible to know every single conceivable gun law that can be made up as you cross from one part of a state to another part of a state, going through countless villages, towns, counties, cities. You don't even know when you're in one place or another. So if you allow every one of these places to have different independent gun control laws, it's simply impossible to comply with because you don't know where you are, and it's impossible to know all the conceivable different gun control restrictions in all these places, which is a major reason why you have state preemption laws. I should warn all of you right here and right now that one of the things that the anti-gunner movement wants to do is get rid of these preemption laws to make it exactly do what should not be done as a matter of a rule of law. They want to make it impossible for American gun owners to comply with the law so they can throw all of us in prison. That is the goal, or at least disarm us. They want to make it impossible for people to comply with American gun laws. That is their goal. And in many places, they want to get rid of these state preemption laws to make it more complicated for gun owners to comply. But, we'll see if that happens. But that is certainly a goal of the anti-gun lobby in a lot of these blue states. Okay? All right. Hope you learned something here today at the Four Boxes Diner. If you haven't subscribed, please do so. Don't forget to share and follow me here. And don't forget to follow me on X at Four Boxes Diner. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.